the procedural manner in which this law and this veto override was conducted during a lame duck session.
And I'm sorry, you mentioned, I want to ask, what do you mean when you say lame duck?
Meaning it was passed during a session after the general election, when the voters of this state had voted in enough Democratic lawmakers to break the Republican supermajority, to break the supermajority that would have been able to enact SB 824 in its enacted form over the governor's veto. And this isn't just some esoteric academic theory. This comes from the mouth of legislative defendant's own expert witness, who said acting during a lame duck session, as this legislature did, is, number one, consistent with the majority wanting to wield its power to the maximum extent, and number two, consistent with a theory that they did not want to pass a watered-down voter ID law. In other words, they didn't want to pass a voter ID law that would have attracted enough support from their Democratic colleagues to override Governor Cooper's veto. I think we can infer that that ID law would have at a minimum been more flexible, and so we would be dealing with a different statute, and that is part of what we would have to consider.
Well, counsel, I'm sorry, Justice Allen, let me finish this point. Under that definition, would the decision rendered by this court in December have been done by a lame duck Supreme Court?
It would not have, Your Honor, for the simple reason, and I'm sure that if I'm misunderstanding the court's procedure, you will correct me, but my understanding is that the case was submitted at the conclusion of the hearing. Obviously, the court speaks through its orders, but that case was heard by the prior court before the election in October, is my recollection. The case was submitted. The fact that the opinion came out in December, I don't think is in any way analogous to what the legislature did in enacting SB 824. And part of the way I think we know that is that other constitutional amendments that were approved by the voters that also required implementing legislation, including Marcy's law, that legislation was deferred to 2019 when the incoming legislature was seated. So I don't think there's any question, but again, I'll defer to the court on its own practices, that a case that was submitted during last year's term could be deferred and held over to be decided by a different composition of the court in this term. That's just simply not factually the same thing. I think it's apples and oranges.
So you would say it's like proposing legislation before an election and then enacting the legislation after the election? I mean, is it not true that the court only speaks when we render our decision?
I agree with Your Honor that the court speaks through its orders. There's no question about that. I'm simply saying that when the case is submitted during the prior term, I'm not aware of a mechanism by which the court could then defer rendering its decision under a new composition of the court. That's why, in my understanding, we're here on a petition for rehearing.
I can't speak for the Supreme Court. I'm sorry, Justice Allen, quickly, I want to make the observation, at least at the Court of Appeals, it happens routinely, and the thing that happens is you rehear the case, which is, I believe, what we're doing right now.
That's right, Your Honor. We are here on a petition for rehearing. I was simply responding to Justice Berger's question about whether the fact of the court's December 16, 2022 opinion coming out after the election was analogous to what the legislature did with SB 824, and it's not, for the reasons that we've discussed previously.
Thank you, counsel. I'll hand it to Justice Allen.
Well, not quite, but counsel, Justice Allen, I'll be there momentarily. But counsel, just getting back on this point that's been raised, and looking at that which we are supposedly gathered for, which is to look at what happened in this case on the trial court level in terms of whether or not Arlington Heights was properly applied. In looking at Arlington Heights factors and in looking at history coupled with circumstantial evidence, is it your position that the lame duck session at which the law at issue passed and is being considered here along with other factors, irrespective of the composition of this court at the time that this case was originally heard, but what the trial court did in this case is a lame duck session composed of some legislators that passed an unconstitutional voter ID law upon which there's some evidence that could be considered, coupled with other factors, something that was appropriately considered here in the Arlington Heights factor test application.
That's exactly right, Your Honor. The nature of the legislative session in which SB 824 was enacted, the procedural history that break from legislative norms are all pieces of evidence that the trial court was perfectly able to consider in reaching its judgment. And the trial court found that each of those things were indicative of intent, and it didn't have to reach very far to reach those conclusions, in part for the reason I mentioned previously, which is that one of defendants' own expert witnesses said acting in this manner is consistent with this kind of entrenchment theory. Acting in this manner is consistent with not wanting to pass a watered-down version of a voter ID law. Acting in this manner is consistent with not wanting to pass a version of the law that would have attracted enough bipartisan support to override Governor Cooper's veto with Democratic voters included, or Democratic legislators included. And so the idea that the nature of the legislative session and the nature of the legislative history in which this bill was enacted could support an inference of improper intent under our theory of the case, I think is not a stretch at all, and is something that, from my perspective in the trial record, in the evidence and the testimony that the trial court heard in person and considered the credibility of and weighed against all of the other evidence, was something that came from defendants' own witnesses. And so it's really not much of a stretch at all. I see that.
May I ask my question, if I can still remember? So you mentioned that the idea that the legislature acted in what you call a lame duck session to avoid having to pass a watered down version of the voter ID law. So I'm just curious as to what you think that would be, because the law in front of us provides IDs free of charge, and as I think has already been explained, doesn't actually prevent anyone from voting. A person with a reasonable impediment can vote without an ID. A person who forgets his or her ID can vote and then come back, I think within a 10-day period, to show that ID. So what would be a more watered down version of voter ID than a voter ID law that allows people to vote essentially without a voter ID?
Your Honor, I think it's important to distinguish between casting a regular ballot and casting a provisional ballot that may not count. There was evidence in the trial record that voters under HB 589 who cast provisional ballots, many of those provisional ballots were not counted, and that, in fact, there was a racial disparity in the breakdown.
Are we to assume that the General Assembly intended for the law to be improperly administered, or are we to assume that it intended for the law to be properly administered?
I don't think you need to assume that the legislature intended for the law to be administered improperly to still credit the trial court's conclusion.
So would you agree that if this law is properly administered, no one who has the right to vote would be denied the ability to vote or cast a provisional ballot?
If the law is properly administered, someone who does not have an acceptable form of ID could cast a provisional ballot. That is a different question from whether...
So how is it relevant to us if administrators fail to follow the law properly?
Well, it's relevant, Your Honor, because
Well, how is it relevant to the issue of legislative intent? And I'll let you answer.
Thank you, Your Honor. It's relevant because a considerable portion of the defense of this law was that you cannot infer bad intent because of the presence of a reasonable impediment provision. If the reasonable impediment provision doesn't work, that's not very good evidence that the legislature couldn't possibly have had an improper intent.
And isn't it true that there were amendments that would change how this law operates that were rejected during this process? And isn't it true that many states have a signature alternative? so that persons who don't have an ID can sign a statement under oath saying they are who they say they are and they can vote.
That's correct.
And wouldn't that be more watered down than what exists now?
It would be, Your Honor, and as would a law that included additional forms of ID, as would a law, frankly, that was the product of study by the legislature to arrive at a determination of what the most inclusive version of a voter ID law might look like. None of that happened here because the legislature had to rush SB 824 through in the lame duck session so that they could pass their preferred version of the bill before racial gerrymanders were undone, which would have further shifted power to, or were expected to further shift power to the Democrats. And all of those things were facts that the trial court seized on in reaching its ultimate conclusion that there was evidence in all of the Arlington Heights factors indicative of discriminatory intent. I'm running very short on time, and so I just want to respond to a couple of points that were raised by my friend in his argument. The first is that under Arlington Heights, the standard is whether the law bears more heavily on one group or another, not whether the law will perfectly disenfranchise one group or another. This law does bear more heavily on African American voters because they're disproportionately more likely to lack qualifying ID, more likely to face difficulties acquiring ID, and as we saw under HB 589, more likely to run into difficulties with the reasonable impediment provision. And in my last few seconds, I also just want to briefly touch on whatever the similarities between clear error and competent evidence. What the competent evidence standard no doubt means under this court's precedent is that a trial court's finding is not wrong just because you might also be able to draw a different conclusion from the facts. That's all that the appellants are asking this court to do, is draw their preferred inference from the facts.
Thank you, counsel.
Thank you.
Rebuttal.
Yes, thank you, Your Honor. I'd just like to make a few points. First, opposing counsel has conflated the issue of the burden of proof and the presumption of good faith. The question was asked where in the trial court's decision was a presumption of good faith. The answer was it's not, but he acknowledged when the burden of proof changes. Those are distinct issues. One is who bears the burden of proof, and another is whether there's a presumption of good faith that is applied when analyzing the evidence that was nowhere in the trial court's decision. Two, an attempt was made to distinguish between what happened in Abbott v. Perez versus what happened in this case, but it's exactly the same. One attempted distinction was, well, they relied on an interim court decision that eliminated racial discrimination. But here, the General Assembly relied on a statute that was judicially held in South Carolina to not be racially discriminatory, and then actually made it much more voter protective. The reasonable impediment provision that was in HB 589 that in fact was not credited at all in McCrory because it was not in the initial bill, but in any event that it was in HB 589 was much stricter than the reasonable impediment provision in SB 824. It was an impediment to obtaining an ID versus presenting an ID. So under the reasonable impediment provision in this legislation, people that forget IDs can cast a reasonable impediment ballot. There are no ballot challenge. Yes, Your Honor.
I'm sorry to interrupt you,
Yes.
but I do want to ask about something that hasn't been
Yes.
directly raised, although I think this is relevant to the issue of the timing of the court's decision and your much earlier suggestion that a presumption of correctness shouldn't apply to our first decision because we ruled so quickly. And I want to refer you to the state defendant's supplemental brief, which was filed on rehearing, where the state said all defendants agree that implementation of the law will require significant lead time. Specifically, the state board and its partners will need to engage in outreach efforts to raise public awareness about the law and its requirements, conduct trainings, develop software changes to the election information management system, and engage in rulemaking. State defendants respectfully request that this court take these logistical necessities into account in its resolution of this case. Do you think the need for lead time and those kinds of logistical necessities and the importance of voters knowing what may or may not be required of them when they go to vote, that those might be matters that would urge this court to act expeditiously?
It's possible, Your Honor, although when this case was expedited, one of the reasons that was argued against expediting was this would be confusing to voters because it would be happening right when the election was happening, but nevertheless, this court chose to expedite the decision. But even if that's true, it doesn't change the fact that it was done hastily and perhaps mistakes were made. As I indicated, there are 4 or 5 basic factual mistakes in the majority opinion, which perhaps bespeaks the haste with which it was made. That doesn't mean it was wrong to act hastily, but it doesn't change the fact that there was haste involved.
Counsel, and I
Yes.
just one last thing on that. So also this sort of clock, if there is one, of how quickly
Right.
that would only start running after the court issued a decision, right? As long as the case was under submission, no one was going forward with voter ID here in North
Correct.
Carolina. Correct.
There was an injunction in place, Your Honor. With respect to, mention was made of racial data, and this is just indicative of the way the evidence has been treated in this case. In HB 589, the General Assembly was blamed for seeking racial data and saying this is indicative of racially discriminatory intent, that you sought this racial data and then enacted these laws. So this time, the General Assembly does not seek racial data, and yet that's held against them again. It's like a catch-22. Regardless of what they do, it's going to be held to be indicative of racially discriminatory intent. But instead, what they did was, again, they relied on a law that had been judicially pre-cleared in South Carolina, but made it much more voter protective. The array of IDs that are in this statute, as far as the evidence in the record showed, is the narrowest possible racial disparity that could be had in South Carolina. And it's clear that the burden of proof, I just urge the court to read paragraphs 230, the heading between 109 and 110. It was not a mere attributing memory to the General Assembly. It was flipping the burden of proof. And finally, the Callahan testimony, Callahan clearly said that acting in a extra session is normal.
I believe your
Thank you.
time has expired. Thank you. Thank you, everyone. Mr. Clerk.